And while the Supreme Court has asked the CBI why it needs the government's permission to probe government officials, the Attorney General of India, G. Vanvati, has said that under current laws, prior approval of the centre is necessary before any investigation is carried out into an offence by a Joint Secretary level officer and above, and that the Central Vigilance Commission cannot direct an investigation on its own. The Attorney General was asked for his opinion by the CVC. That is bound to create more controversy as this issue continues to be debated. Well, joining us on the program tonight, we have from the left Mr. D. Raja, National Secretary of the CPI, Sudhanshu Trivedi, spokesperson of the BJP. We'll be joined shortly by Abhishek Singhvi, spokesperson of the Congress Party. Here in the studio with us, U.S. Mishra, former director of the CBI, and Parunjoy Guha Thakurta, political analyst and economist. Let me ask Parunjoy first. What is the big takeaway from today's Supreme Court hearing? Everyone was waiting to see what the court would say. One, on the issue of the CBI's autonomy, and two, on the probe itself. And on both issues, the government seems to have got a bit of stick.
Yes, the government has got a bit of stake. It should have got it, but nothing has happened really. What the government, what the CBI, what the Supreme Court has said, that the Parliament has to amend the law. Right now, what the government is merely a suggestion about the way in which the director of the CBI should be appointed. And what is new is really, the involvement of the leader of the opposition as part of the panel that finally decides on the name. Now, we've seen in the case of what happened in the case of Mr. P.J. Thomas, it's not as simple as that, I mean, in the case of Mr. P.J. Thomas, the government had to eat humble pie because on one side was Mr. Manmohan Singh and Mr. Chidambaram, on the other side was Mrs. Swaraj, and they overruled her. But I think the bigger issue is when you're looking at the CVC, that's a Central Vigilance Commission. It's a powerless body. There are hundreds of examples where the CVC has gone through entire investigation. They've recommended the prosecution of government officials or officials who are working in government department or public sector.
And they don't get the sanction for it.
And they don't get the sanction. So why have an organization like this which is utterly toothless, and why have an entire establishment to do what? I mean, at the end of the day, even if the CVC does its job well, diligently, no action is taken against the person. So it's about time. I think we need to completely amend this law. I mean, and this whole thing about prior sanction, it just doesn't make sense. I don't know which other country in the world has this kind of a law.
So let me take that to Abhishek Singhvi. Abhishek Singhvi, first we're talking about the issue of prior sanction for prosecution. The Supreme Court today said, why is prior sanction required if it is a court-monitored investigation? At the same time, you have the Attorney General saying in a reply to the CVC today that the CVC will require permission from the centre when it comes to prosecuting a senior government bureaucrat. That is what the law is, and that is how it should be. But as Parunjoy says, is that in today's day and age something we need to reconsider?
There are two answers I want to give, Nidhi. One is what I personally feel and what Parliament has collectively felt at a point of time, and the second is what the law is. I personally believe that sanctions should not be there, should not exist, and I have walked the talk in that we have a very detailed paragraph in the Lokpal report, which when I was the chairman of the committee, which tells you why the sanction provision should be scrapped. And I think there is merit in that. Now that's on the record, so I'm not saying something which is totally my opinion. It has been the collective opinion, and I went into some detail. As far as the current law, however, is concerned, it's a statutory provision. And when a statutory provision stands, there is one in 197 of the IPC. There are other provisions in other acts. There is a modified version of it in a single directive, the infamous single directive, which the Jain Hawala case onwards has come in for much comment. Now the real point is that as long as the provision stands, the government and the courts would have no option but to either follow it or distinguish it. I think it has been considerably whittled down already, you must remember that, because the argument in most cases is that if you commit a murder, I don't need a sanction because it can't be a course of your duty to commit a murder. Or if I commit a rape, you can't need sanction because it can't be the course of your duty to commit a rape. So already sanction is not required in most cases. But where the event, the act or the omission involves something which has color from the seat and office the person occupies, then today there is a statutory provision. Now what does the court do about it? What does the Attorney General do about it? He can't get up and say ignore a statutory provision. So really it requires parliamentary modification or repeal. Otherwise the sanction provision stands. And I hope and trust that our original Lokpal recommendation through the select committee will ultimately lead to a dropping of the sanction in the bill and the act when passed by Parliament.
But isn't it significant today that the Supreme Court has actually said, why do you need this sanction for prosecution if it's a court monitored probe like it is in the coal issue?
Now, a very important question, Nidhi, and this is how law develops in the Indian system and the English system by incremental development case to case. So the normal principle is sanction is required howsoever bad it may be, and I am one of those who is saying it should go, but the provision stands, so it has to be got. Then the court gives a gloss to it by saying, look, yes, sanction will apply normally, but in a special subcategory by interpretation we hold, it will not apply to a court monitored. Now that's a very good and a very valid way of doing it. So you will have a further whittling down of 197 by saying that 197 will not apply where the court monitored investigation is on. I personally think it's a good thing. It has already been said in other cases that 197 will not apply where the act is so blatantly beyond any nexus with the office or the seat or the color of office that the person holds, that it can't be in the discharge of his official duties, and therefore no sanction is required. That's another gloss. This is how the law develops, and this is the way it should develop.
Okay.
So I have no problem if the court so holds. If it holds, then from tomorrow, for court monitored investigations at least, this exception will apply.